5 seconds to go. Start. Hence, it follows that clause thirdly of section 300 will apply in this case. We are constrained to observe that the High Court adopted an easy method of accepting the only contention canvassed that the offence made out was culpable homicide not amounting to murder. As noticed earlier, the High Court ignored that there were injuries on the vital parts of the body of the deceased. The High Court did not notice that all the elements of thirdly in section 300 were established. It was argued that the accused took the deceased to a doctor, which shows the absence of intention to kill him, apart from the fact that, for the reasons recorded above, the absence of intention to kill is not relevant in the facts of the case. The injuries found by PW3 on the face of the deceased, which were not the ante-mortem injuries, establish that before throwing the body of the deceased in a canal, his face was completely smashed by the accused. The fact that accused, after killing deceased Balveer Singh, went to a common relative will not be of any assistance to the accused. The view taken by High Court in the impugned judgment and order that the offence under section 300 was not made out is not even a possible view which could have been taken on the basis of the evidence on record, as we are of the view that the High Court has committed a gross error by applying section 304 part 2nd of IPC. The judgment and order of the High Court will have to be set aside, and the judgment and order of the Sessions Court will have to be restored. We hold that the learned additional district and sessions judge was right in convicting the accused for the offence punishable under section 302 149 of IPC. Accordingly, the appeal is allowed by setting aside the impugned judgment of the High Court dated 18th July 2016. We restore the judgment and order dated 26th September 2011 in session case number 4 of 2006, passed by the learned additional district and sessions judge, fast track number 1, Hanumangarh, Rajasthan. Therefore, the substantive sentence and the fine imposed by the Court of Sessions for the offence punishable under section 302 149 of IPC is restored. We direct the accused to surrender before the trial court within a period of 6 weeks from today. If they fail to surrender within 6 weeks from today, action be taken by the trial court for arresting them in accordance with law. they shall undergo remaining period of sentence in terms of the judgment of the trial court dated 26 September 2011. Stop.